He called himself a living, breathing man and told the judge he didn't consent to the court's authority. What happened next completely changed his future. In this courtroom showdown, a self-represented defendant rejects a plea deal that would have kept him out of jail, and instead talks himself into multiple felony charges, possible prison time, and a full jury trial. This is what happens when sovereign citizen arguments collide with real courtroom authority.
We'll call People versus Austin Wright, 25 CR 1212. I'll take appearances. Ms. Raines.
Good morning, Your Honor. Katie Raines on behalf of the people.
Thank you. And sir, if you'd say your full name, please.
I am the living, breathing man, Austin James Wright Jr.
Mr. Wright, I will consider that you have entered your appearance. I will say that I acknowledge your non-conventional entry each time requested. I don't know if that's an attempt to lodge an attempt at a sovereign citizen entry to suggest that the court does not have jurisdiction over you. I will simply let you know if at any time I'm not aware of whether or not Austin Wright is present, I will have to issue a warrant for his arrest. I acknowledge your appearance, Mr. Wright. You have entered that appearance. There is no need for such a warrant this morning. Good morning to you and Ms. Raines. We're set for motions, and the reason the court set this motions, and it was an additional motion setting because the court wanted to make very clear to Mr. Wright that we were set for this motions and that the court wanted to clarify any motions filing deadline and the court's deadline for any plea cutoff. I acknowledge Mr. Wright's previous filing as it relates Mr. Wright, you filed a motion on August 4, 2025, and the court previously ruled on that. I acknowledge it just once again because the court recognizes that there have not been additional filings since then. The court recognizes the motion is based on a concept of corpus delicti. The court's already ruled, and Ms. Raines, let me look to you and ask you just to bring me up to speed on status, and I'll give Mr. Wright the same opportunity.
Yes, Your Honor. An offer has been extended. I can make a lawful record. My understanding is that Mr. Wright does not wish to accept the plea offer and wishes to have a jury trial.
Mr. Wright, is that your understanding? Is that what you don't want to accept the offer and you want to go to trial? It is your right. I'm just making sure to clarify.
Well, there's a bunch of things that I have questions about.
Other than what's afforded by law and when there's an opportunity for a preliminary hearing. Your motion I read to be one in which there is challenge of probable cause. I previously denied that request based on your plea of not guilty, your challenge that there's insufficient law.
Look, I didn't plead not guilty.
Mr. Wright?
You entered that plea for me.
Mr. Wright, you're interrupting me, sir.
From the bench.
Mr. Wright, you interrupted me and I'm going to finish talking. First of all, you asked me why I had not given you a hearing on that motion. That motion I ruled on. I don't find anything further that requires a presentation of evidence or further hearing. I gave you until November 12 to file any additional motions. None were filed. Today we're set for that motions hearing. Mr. Wright, I've given you that opportunity. As far as your not guilty plea, I'm not going to cause delay waiting on you to enter yourself a plea of not guilty. So I entered it on your behalf, which is the option preserving your constitutional rights if you do not enter a plea of guilty. So that's why I've done
attention to anybody's constitutional rights, and you don't try the law and you don't try the facts.
Mr. Wright, we don't have a jury trial. Today is not the jury trial in which we are going to try the facts. Now, Mr. Wright, I'm going to give Ms. Raines an opportunity to explain what the plea offer is. And Ms. Raines, if as part of the Lafler-Frye, you wish to go through the present 8 charges in which the court has entered a plea of not guilty on behalf of Mr. Wright, discussing what the possible penalties are, the court would accept that as part of the record. Mr. Wright, do you have something to write with?
Yes.
All right. If you wish to take notes of this, I'm going to ask if you've heard, understood this. This is giving some context of whether or not you understand there was a plea offer, possible consequences, and if you wish to then not accept that offer, which you do not have to take, and you certainly do have a right to a trial, including a jury trial.
I don't accept the offer.
I understand. That is very clear, but I need to make sure as part of the record what the offer is, because I don't know what it is, and we're going to make a record for your benefit what that offer is that
Right.
you're declining.
So this is a court of record.
Ms. Raines.
Yes, Your Honor. I will go through the original 8 charges first. As to both counts 1 and 2, they are both class 5 felonies. They carry the possibility of up to 1 to 3 years in the Department of Corrections. There are also probation eligible offenses. Count 3 is a traffic 2 offense that carries a possibility of jail from 10 to 90 days or a fine of $150 to $300 or both. Driving under the restraint is a traffic infraction A. It carries a possibility of a fine between $15 and $100. Count 5 is a traffic infraction B that carries the same possible penalty as count 4. Count 6 is also a traffic infraction B, so same possible penalties as the 2 previous there. No insurance is also it's a traffic 1, so it carries a possibility of jail from 10 days to 1 year or a fine of $300 to $1,000 or both fine and imprisonment. And count 8 is a traffic infraction A, which again carries a fine of no less than $15 but up to $100. The plea offer that was extended to Mr. Wright in this case contained 2 charges that he would have pled guilty to. One was a defective vehicle, which was a traffic infraction A, so a fine of between $15 and $100, as well as a plea to a misdemeanor 1, possession of an illegal weapon, which carries the possibility of up to 364 days in jail or up to a $1,000 fine or both. That plea would have required Mr. Wright to forfeit the weapons that law enforcement discovered during their investigation. And part of the agreement was that I would not have objected to a probationary sentence. That was emailed to Mr. Wright on October 10th of 2025.
Mr. Wright, were you able to hear and understand Ms. Raines' statement of the charges, the possible penalties if you were convicted, and the plea offer?
I comprehend what she said.
All right. And Mr. Wright, I think you have made it very clear to me, but I wanted to make sure that you understood that. Is this plea offer to plead to a traffic A with a fine of $15 to $100 and a class 1 misdemeanor possession of an illegal weapon with an agreement that you would forfeit the weapon and no objection to probation? Is that something that you do not wish to enter into and that you wish to rather proceed to trial on all counts 1 through 8?
I want to first know who the injured party is.
Mr. Wright, let me ask you this. Do you want to enter into this plea agreement or decline it and go to trial? Do you want to go to trial and not enter into that plea agreement? Because you answered yes, but I didn't know what you were answering yes to. I'm giving you a chance to clarify.
I do not want to enter into the plea agreement, and I still do not consent to the authority of this court over my person, my body.
Talk about voir dire and jury selection. So voir dire, the process, we will have 25 minutes for voir dire with 2 minutes for replacement. And let me explain what that is, recognizing Mr. Wright is representing himself. So in the jury selection process, what we'll do is we'll have one alternate. We'll have 25 people in and in front of the jury box. Those people seated in seats 1 through 13 will be the presumptive jurors that will be selected. The person seated in seat 13 will be the alternate. No one is to inform any prospective jurors or jurors that there is an alternate or who that is. What we'll do is the court will conduct a voir dire, a jury selection, to make sure that there's no one who is by law not permitted to serve as a juror present. Both sides will have 25 minutes to ask questions of the prospective jurors. If there's anyone that is excused for cause, meaning that there is an extreme hardship or that they don't qualify, then there'll be need to replace those people from someone in the back of the courtroom, a prospective juror who has answered their summons. And so by replacement voir dire, that's what I'm talking about. And each side will have 2 minutes to ask questions. To be clear, jury selection will be based on, will be questions permitted will pertain to the appropriateness of a prospective juror to serve, their ability to follow the law, and to be objective. The court will limit opening statements to 15 minutes and closing arguments to 20 minutes. If anyone needs any parties, attorneys, witnesses, need any interpreters or Americans with Disability Act accommodations, I'm requiring that at least 21 days prior to trial that you notify me of that so I can find appropriate accommodation. I'll require the people and Mr. Wright to both submit to the court and file a list of possible witnesses that may be called, because I will ask of the prospective jurors if they're familiar with anyone in the courtroom, including me, you, any of the possible witnesses. And to ask that, I need to have a list of your possible witnesses. So I'll want that 21 days prior to trial. Ms. Raines, and I'll ask Mr. Wright the same question. Do you have a request as to the old or new reasonable doubt instruction?
The people would request the new reasonable doubt instruction.
Mr. Wright, do you have any position on that? The Supreme Court has recently updated the reasonable doubt instruction. There is an old one we refer to. There is the new one now. Do you have an opinion as to using the old or new one, which would ultimately be the instruction to the jury as to what reasonable doubt is?
I would have to understand what they are.
What I will do is order that the new is to be used, subject to Mr. Wright timely presenting to the court any request to the contrary. That will need to be filed at least 21 days prior to trial.
Where do I find this new definition?
So you can go to the court. Do you know about the Court Resource Center, Mr. Wright?
Mm-hmm.
I didn't understand if that was a yes or no.
Yes.
Yes. If you go there, while they can't give you legal advice, they may be able to point you in the direction of obtaining what that is.
You changed the definition of probable cause?
No. Ms. Raines, would you agree that this is instruction on Cole G? I've got E3. I
Yes,
was
Your
going to
Honor.
just print this out for Mr. Wright as a courtesy so that he could easily then see what the current one is and what the old one was. So, Mr. Wright, I'm going to print this out for you and give this to you so you can read this.
I appreciate that.
Yes, sir. I got to be careful not to give you legal advice, but this is part of the discussion.
It's in writing.
Mr. Wright, we'll ask the judicial assistant to give this to you. Thank you, Ms. Organ. Thank you, Mr. Wright. So 21 days before trial, if there's any objection to using the new Mr. Wright, I'll receive any request. As far as live streaming, so Mr. Wright, one thing that we have going on right now is that we've got WebEx up. You can see that, but our legislature requires that in criminal cases, unless there are certain exceptions, that we also live stream, which we're doing right now, so that people can log in and watch these proceedings, and we don't even know who they are. Ms. Raines, is there any objection to the use of live streaming beginning at the time of the opening statement and throughout the parties' presentations of evidence?
No objection.
Mr. Wright, do you have any reason to object to that?
No, I insist on it.
Okay, then we'll certainly use that. We'll have jury instructions due at least 7 days prior to trial. Mr. Wright, you may present, if you want, a theory of defense instruction that I would contemplate and determine, as I would the people's proposed jury instructions, whether or not it's appropriate to present to the jury. And so if you wish to do that, you may submit that to the court as well. Also, within 7 days prior to jury trial. Mr. Wright, I'll let you know that because you do have the right to remain silent and that you don't have to disclose specifically your trial strategy, if you wish to submit that theory of defense and not submit it to the people, I'd consider receiving that, what we call ex parte, without the people receiving that for my contemplation, so that I could consider whether or not it might be something appropriate to ultimately go to the jury summarizing your theory of defense. It is not a requirement. You don't have to do it, but that's something that you may wish to do. That would take care of the pretrial conference, pretrial readiness. I would propose that we not have another hearing unless it's necessary or one is requested before January 14, Ms. Raines.
I'm sorry, can the court repeat that?
Yeah, any need for a pretrial conference, pretrial readiness conference before?
I don't have any need. If there is any, I guess, continuance issues that would arise on our end, the people can file a motion with the court.
Okay. Mr. Wright, the next court date is January 14. That's the date for jury trial. Is there any need for a setting prior to that?
I don't see one at the present.
All right. You, as Ms. Raines, may file a motion if there's any need to, stating what you're requesting and why. What I've done is tried to address these things about jury selection today so that you don't have to come into court today and to help reduce the number of times you have to appear. But if there is something that I need to take up with you all, I certainly will. Ms. Raines, Mr. Wright, good luck. I'm going to excuse myself. If you do wish to stay and talk, you may. If you wish to be excused, you certainly may as well. With that, parties are excused, and the court has recognized we have passed the court's plea cutoff deadline, so the court has every expectation that we will be going to trial.